Okay, so this is lesson 35, Affirmative Action. The interests of women and minorities have converged. They have converged on the issue of affirmative action, policies requiring special efforts on behalf of disadvantaged groups. Affirmative action involves efforts to bring about increased employment, promotion, or admission to like schools and things like that for member groups. The goal of affirmative action is to move beyond equal opportunity toward equal results. Okay? If you remember in Chapter 1, we talked about how in a lot of other societies, there's more of a, like in Scandinavia, the Scandinavian countries, they try to level the playing field more. They try to create more of an equality of results. That's why there are all these good Scandinavian doctors in the U.S., because they leave there, because they do all that medical school and then they don't get paid that much better than a lot of other people in Scandinavia. So a lot of them say, hey, I'll just move to America. Well, they'll pay me tons. They still are a very specialized field. The federal government has mandated that all state and local governments, together with each institution receiving aid from or contracting with the federal government, has to adopt an affirmative action program. So if it's government related, basically it's open to affirmative action. And if you don't want to do any business whatsoever with the government, you could try to avoid affirmative action. It's pretty tough to do. Some groups have claimed that affirmative action programs constitute what is kind of a misnomer, reverse discrimination. So you can't really reverse discrimination, you just discriminate against another group. What they're really arguing is that it will discriminate against white folks, or possibly Asian Americans. I was reading up on some results. It's harder for an Asian American to get into school because their test scores tend to be higher than everybody else's. So if their cut score is higher, harder to get in. So here's the reverse discrimination case that everybody needs to know. Regents of the University of California versus Bakke, 1978. The court rejected a plan at the University of California at Davis that set aside 16 of a total of 100 places in the entering medical school class for disadvantaged groups. The court said a university could not set aside a quota of spots for particular groups. However, the court said that a university could adopt an admissions program where race or ethnic background is simply one element in the selection process. So you'd have a system where you award people points for consideration, and then you get some extra points from being from a disadvantaged group. But you couldn't set up a system where you say, no matter what, we're going to give 16 of 100 places to racial minorities. So they said you couldn't do the quota, but you could do this other thing. You could include it as one of the things you look at. The following year, the court ruled that a voluntary union and management-sponsored program was not discriminatory because the Kaiser Aluminum Company's special training program was intended to rectify years of past employment discrimination at Kaiser. This is the case United Steelworkers of America, AFL-CIO versus Weber, 1979. So, a voluntary union and management-sponsored program. So a special training program for racial minorities, I would assume. Maybe women. In other cases, the court has ruled that public employers may use affirmative action plans to counter underrepresentation of women and minorities. But the court has also ruled that affirmative action does not exempt recently hired minorities from traditional work rules specifying the last hired, first fired order of layoffs. So you can have kind of that point system again, where it's one of the factors. It just can't be the only factor. You can't do quotas. So opposition to affirmative action policies, like this Nathan Glazer guy that you may have read about already, who changed his mind later. Surveys find that most Americans oppose affirmative action programs, even though Americans in general support non-discrimination in employment and education. The trick with affirmative action is fairness. And I would assume most of the people who oppose affirmative action are afraid that it won't be fair. Whatever that is. Difficult to figure out what everybody will agree on is fair. Opposition is especially strong when people view affirmative action as reverse discrimination, where less qualified individuals get hired or are admitted to educational or training programs. And you can see why that'd be controversial. I mean, everybody's got a kid. Well, not everybody, but a lot of people have kids. And if you're a white guy and you've got a white kid, you might not like the idea of them missing a cut score and someone coming in who is not white getting that position. Not because you have any issues with race, but because you want your kid to have the best chance they have to get in. So you see why this is controversial, right? You know, it's hard to get people past self-interest, especially when it's their children that they're worried about. In 1996, California voters passed Proposition 209, which banned state affirmative action programs based on race, ethnicity, or gender in public hiring, contracting, and educational admissions. Ultimately, the U.S. Supreme Court will decide this issue. A very similar law was passed in Michigan in 2006. Your book doesn't talk about that. The Michigan Civil Rights Initiative 2006. And it has decreased the number of African Americans, for example, in colleges in California. A federal court of appeals placed a similar ban on universities in Texas, Oklahoma, and Mississippi, while another court upheld racial preferences at the University of Michigan in 2002. So this stuff is kind of still up in the air. Affirmative action, they just haven't figured out what the standard is, what rules should be applied.